Our first panel after the break is a legal review of the status of Ireland's energy transition. And this is being moderated by Mr. Peter McLay, who is a partner of construction industry and utilities at Mason Hayes & Curran. They're all from Mason Hayes & Curran, so I'm going to dispense with that. But Peter's down the end. He's also joined by his colleague, Emer Shelley, who's a partner in corporate governance and ESG, Rob McDwyer, who's a partner in construction, infrastructure and utilities, and Jay Satin is a partner for planning and environment. It's a complicated area, the whole world of the law around this, but no better company to cut through the noise than the company who are sponsoring today's event. Peter, I'll hand over to you.
Indeed. Thank you, Jonathan. And I liked how you skipped over the panel of lawyers when talking about the interesting speaker to come. But that's fine. We won't dwell on that. But
I was hoping you wouldn't notice that. But
no, we notice everything. No, it's a privilege to be here in Cork, and thank you all for coming out. Those based here and those who have travelled, it is much appreciated. I was on the, obviously we all know about Cork's proud history as the place where all Irish hydrocarbons came from originally. I was also on the South Mall yesterday and I walked past a woman with a sign saying, "Climate Strike, 1 p.m. Friday." So that to me says that Cork is in tune with the climate zeitgeist, and it could be something to do for those of you who are here or hang around on Friday. So it's come for the conference, stay for the climate strike. But anyway, look, without further ado, this is a legal panel in the context of a conference entitled "The Future of Energy Investment in Ireland." And I won't win any originality awards for saying that investment benefits from requires certainty. There's many areas of uncertainty, and the legal framework, unfortunately, is one. Now, there's nothing I'd like more than just to say that the law hasn't changed since last year, and to send you off into Mr. Mundy's capable hands. But unfortunately, that's not the case. The Irish energy legal regime continues to develop, continues to stay complex, and that's why we think it's worth a panel slot at this event today. So, I think an indication of that was the very fact that even yesterday, at European level, in a State of the Union speech, President von der Leyen hinted at further changes along the way, as I think you can speak to, Rob.
Yes. Ursula von der Leyen was giving her annual State of the European Union speech yesterday, so she mentioned that the Commission is going to be introducing a new wind power package. So we don't have any great level of detail on it yet because they're going to be working on it with industry and member states, but she mentioned a few key points. So one of the things they're going to be looking to do is speed up permitting even more. She said, I'd say people might say it hasn't really been sped up much yet, but the goal is to speed it up even more. And then also, interestingly, talking about improving the auction systems across member states, and then also an emphasis on the need for skilling up and also supply chain issues. And basically recognising a lot of the issues that the wind industry is experiencing and all those challenges. And there's an intent to come up with a plan for it, so we'll have to wait and see what the details.
Yeah, but it's like buses. These European plans are coming along rapidly, in sequence these days. So it's it's just one more area of change for us to all keep on top of. It's just occurred to me that I forgot to mention the poll. There are.
No, you didn't forget to mention the poll because you're being very polite. And again, they literally paid me to do one job, and I forgot the one job. Right?
We have the contract here.
Sorry for cutting in there, Peter. Very kind of you to take the bullet, but I'll jump back up. We are running our third poll via the app, ladies and gentlemen. So have a look at your phones. If you've clicked out of it, you can go back in using the QR code on the little Yoki Bob. But the questions that are here. What are your views on the EU Corporate Sustainability Reporting Framework? Ireland aims to have 5 gigawatts of offshore wind capacity by 2030. How likely do you think that's going to be? And based on your current understanding of the proposed reforms to Irish planning law, do you expect the effects of the reforms to be either strongly positive, negative, or strongly negative? So remember, we're trying to finish on a high point, so don't answer too honestly to that last one. But anyway, as I said, that poll is up and running now, Peter, and I will bring you the results some way in the middle of the panel.
Excellent, or else I will.
One of
Good. Okay. Well, Rob, you've already mentioned the most recent bombshell from yesterday. Maybe now would be a good chance to just give us a general survey on where things stand in terms of maybe not so much law, but it's more regulation. It's the route to market, the RES and the ORES auctions.
Well, Donal mentioned earlier about RES 3 and the fact that tomorrow at 12 is the deadline for submissions for that one. Donal also mentioned the point that came out of the auction information pack when it came out last week about the indicative volume has been reduced way down. So that's probably indicative of how few projects they're expecting to bid in. But that's gigawatts that are going to have to be made up in later rounds of RES if we're going to meet the 9 gigawatt target by 2030. So that just makes that a little bit more challenging. But it was the maximum offer price for RES 3 has been reduced as well, but people were expecting that. It's only gone down by €10 per megawatt hour. But when you look at the fact that there is partial indexation, I know that's not as much as people want. People want full indexation, but there is at least 30% indexation there now. There's also the compensation for unrealized available energy. So that when you think about all of that, and also the removal of the community preference category, I don't think it was a surprise that the cap went down, but it didn't go down by 2.
Well, I suppose the problem is when you're tweaking caps. I mean, the UK, the recent UK auction has shown us what the consequences of that can be. What may seem like a benign, but an incremental change can actually.
Yeah, we heard a little bit about that earlier as well. But
yep.
There was industry in the UK was calling out for the price for offshore to be increased for that one, but it actually went down from £46 to £44 per megawatt hour. So it wasn't a surprise to anyone that there wasn't a single offshore developer that bid into the auction. So that's creating massive headache for the UK, but that's their problem, I guess, in a way.
Indeed, yeah. And in terms of speaking of the offshore and the coming ORES, the next round of ORES, I guess I understand there's some consultations afoot at the moment here as well.
Yeah, well, there was a consultation on the design of ORES 2 and the terms and conditions for ORES 2. So that one closed just on the 25th of August. So they'll be making their way through the submissions for that now. Now, we do know that there are certain things that are set in stone because of the updated state aid clearance. So the partial indexation, that's not going to change. There's not going to be full indexation. The unrealized available energy compensation, that's going to be there. The 20-year term of support, that's all going to stay the same. Yeah.
I guess a bit of certainty at least.
For that one. But it'll be interesting to see what does come out of this statement from yesterday about improving the auction systems across member states. So maybe that might mean that we will have 100% indexation in future rounds of RES, which would be great.
Yeah, who knows? I mean, they're even asking the audience about the DMAP, aren't they? There's a consultation on that. Yeah,
the DMAP proposal for the South Coast is out for consultation. It's still open until mid-October, I think. So what they've done there is they've identified a proposed area of just over 8,600 square kilometres off the South Coast, but that's going to be refined through a process of public engagement and consultation and environmental impact assessment and analysis as well. There's been Airgrid and crew and other people going around hosting information events around the country. There's been getting targeted engagement from the key stakeholders, because obviously building an offshore wind farm is going to be of a lot of interest to fisheries.
And I guess we've seen things, like an active fisheries industry, needs to be involved. As has been shown.
So they're coming up to the end of those information events now. So I know we've got a lot of people from Airgrid in the room. I think they're having a joint information event in Wexford on Monday. So that would be a good one for people to go along to.
Yeah, very good. And I understand there's some planning environmental implications too. I think, as I understand it, whatever is eventually decided needs to go through full.
Yeah, well, coming out of this DMAP proposal, then they'll refine it down to a smaller geographical imprint, and then they'll issue the draft DMAP, and that'll go out for a further 6-week statutory consultation period. But then that'll be accompanied by a strategic environmental assessment and an appropriate assessment. So
okay, very good. Well, you mentioned that magic word, environment, Mr. Satin. Well, I guess planning has been mentioned, in energy conferences since I can remember, including the previous 2 panels today. But obviously there's a big planning law change about to drop. Could you tell us a bit about that?
Yeah, sure. So I think as was mentioned in previous panels, there's obviously a lot of frustration with the planning system at the moment. So one of the major changes that's coming through is the Planning and Development Bill. So that was issued in draft form in January this year. And as we heard earlier today, that's due to go before the operatives now in a couple of weeks.
Yep.
So as part of that bill, it's a pretty wide kind of sweeping bill. So there's over 700 pages. It's the biggest change in the planning system for the last 20 years. One of the key changes, and we were talking a lot about planning certainty earlier, so certainty in terms of when you're going to get a decision after you put in your planning application. So on-board planola, which is going to be renamed as on-commission planola, will be subject to mandatory timelines. Those timelines were not set out in the draft bill, but they may now come forward in the next couple of weeks. So currently, the board, for example, with appeals, they're not subject to mandatory timelines. They just have the objective to determine the appeals within 18 weeks from when the appeals commenced. But recent statistics show that those aren't even being met. I think they're only being met in about 30% of the cases. And we obviously heard earlier from Donal about there potentially being a year between from when the last wind energy development received consent from the board. So they're going to be subject to mandatory timelines. If they don't meet those timelines, then they'll be subject to a fine. Again, the level of fine's not been set. But if we go anything by the strategic housing development legislation, where they also had mandatory timelines, the fines were basically, as an applicant, you pay your application fee. If the board didn't meet those timelines, then the application fee is paid back to the applicants. That might be the fine that we're looking for.
It's the government fining the government.
Effectively.
Yeah. And does the delay or missing the deadline, does it do anything to the application itself? Is it deemed accepted or otherwise? Or is it
no, it just, yeah, exactly. Not in the draft bill anyway. I mean, it's still, to go through the bureaucracy, so that might change by the end, but no, not in its current format. So you'll have the fines, and then in order to meet those fines, so they're changing the structure as well of the commission. So there's going to be a governance function, which will be overseeing the actual planning function. And the idea behind that is to bring more kind of trust into the actual decision-making process. And there's no point having these mandatory timelines unless you have resources, you have people on the ground who are able to make these determinations. So, for example, if we use the SHD process again, there were a lot of those mandatory timelines were just missed. And also, some of the decisions were just rushed through the system. And then you get mistakes in the actual decisions. And then those mistakes end up in judicial reviews. And then you're actually waiting even longer to get your decision that's safe from challenge. And I'd say not just any kind of resources, you need specialist expertise as well. So you need, for example, ecologists who can look through all the complex appropriate assessment documentation, for example. And I know there is a big push on at the board at the moment to bring more resources. I think they're back up to 15 board members. They're also looking at in-house legal expertise as well, because you always need more lawyers. In the world to review the planning applications, maybe to de-risk them a bit. But there could be other changes as well that they could bring in. Potentially, they could delegate some of the decisions. So rather than it all being made by board members, they could delegate smaller decisions down to specific inspectors. And probably more guidance as well, I think, would be quite helpful. This is how you put together a planning application, and there's more certainty. And this is when we put this planning application in, we know it's correct and it ticks all the boxes.
Yeah. I mean, the slight skeptic in me kind of thinks that much of that resourcing could be done under the current framework without making us wait for and then try and pass through or try and analyse and become comfortable with the new regime. I mean, it's obviously a legal change, but what we're really concerned about is the outcome. So maybe some combination of law change and resourcing is where we need to be. Well, as I mentioned at the outset, the wider context is the investment that we all need to do to meet the state's targets. Obviously, any planning improvement will be welcomed as it makes it more likely that the targets will be reached. Also, very important from a point of view of compliance with the new regime that I hadn't personally heard much about and was kind of surprised to discover its ambit. So. Maybe you will be too. It's the corporate, I'll say it once and then I'll probably hit the acronym after that. The Corporate Sustainability Reporting Directive, the CSRD as I'll call it. Emer, this was apparently enacted at European level earlier this year, and I guess its implementation in Ireland is coming down the pipeline. Can you tell us a wee bit about what it is and why it's so significant?
I can, Peter, thank you. And I'll go straight to the acronym. So as you say, this CSRD was enacted at EU level in January, and it's currently in the process of being transposed into Irish law. And it's really going to have quite a transformative impact on the business landscape, not only in the energy sector, but really across all sectors. But what is it all about? It's part of, and the Minister mentioned this morning, it is part of the EU's action plan towards climate neutrality or net zero emissions in Europe by 2050. But as the name suggests, it's not just about climate, or the CSRD is not just about climate. It goes to this much more broad concept of sustainability. And really what it's designed to do is to enhance and improve stakeholder access to high quality, reliable and comparable sustainability information. And it's going to do that in 3 ways. So firstly, it's going to impose annual mandatory reporting obligations on a large number of companies across the EU, and in some cases even beyond the EU, to make disclosures on their ESG performance. Secondly, those disclosures will need to be made, and the Minister mentioned this as well, in line with this new common reporting framework, so that the reports will be standardised and the information that's disclosed will be comparable from one organisation to the next. And thirdly, and very importantly, those sustainability reports are going to need to be audited. So really it's trying to elevate sustainability information to the same status as financial information and make sure that they're on a level footing in terms of their accessibility, their comparability and their reliability.
Okay.
Quite a big impact and shift for organisations in terms of their approach to sustainability.
And if I understand you correctly, it's about the quality of information, the quality of reporting, not so much behaviour. It's not trying to ban certain things directly, but it's to enforce a standard as to how activities are described, I guess. Is that correct?
That's correct, yes.
Yep.
So it's not, it doesn't impose positive obligations on organisations to actually improve their performance. Ultimately, I suppose that's the intention and the hope that will follow, but within the legislation that we're expecting, it's just about reporting.
Okay. Now, I'm assuming it applies both to, in the context of this audience, both to large energy consumers and, I guess, energy producers. Now, I guess there's a temptation to think that if we're a developer of renewable generation, we can kind of kick back and relax because, our activities are bound to be sustainable just by their very nature. Does that mean that a company like that can afford to relax and, take a casual approach to the whole thing?
I wish it was that easy. I think reporting is not going to be easy for any organisation that's within the scope of the legislation, at least in the first couple of years, and probably even more so for an organisation that has no existing reporting practices, and there are many of them, or for an organisation where its reporting practices are more ad hoc or immature. So if you have an energy company that is reporting already in line with some of the more established voluntary standards like the GRI, they might find it a little bit easier. But really, the challenge for any company that's within scope is to understand what's actually reportable and then to put systems and practices in place to actually gather that information. And that is no small feat. To explain why that is so difficult, these standards, the new common reporting framework, they're known as the European Sustainability Reporting Standards. At the moment, we have 12 of them, but we'll have more to follow. So they list topics. So, for example, we have five environmental ones. They cover things like climate change, resource use and circular economy. We have standards on social, which would include an organisation's own workforce, or the workforce within its value chain. We have one on governance and business conduct. And for any organisation that's within scope, it's going to need to go through all of these standards and identify within those standards what is reportable and what's not. Some of them will be mandatory, some of them will depend on what's called a double materiality analysis, so identifying what within those standards is actually material to the organisation. And once you've identified that, you're then going through a huge number of disclosure requirements and data points, and then having to put practices in place to gather that information.
Yeah,
so
it almost sounds to me as if, in the same way that the accounting standards have evolved over time, it's almost like a development of something similar in the sustainability space, but kind of in warp speed. It sounds incredibly ambitious to me. Any thoughts on that?
It is incredibly ambitious. I think that we've been talking about it now for about 18 months, but we're 4 months out now from the commencement of obligations. So for the first category of organisations, which are large public interest undertakings, their reporting obligations will be commencing next year. So we'll start to see those reports coming through in 2025.
Okay.
So it's moving very, very quickly. And I think organisations should be, if they're not already, in preparation mode at this stage.
Yeah, no, even in our own business, we've noticed that our clients are in many cases requiring information. Now it's not to the I guess the level of formality that you're talking about, but it's certainly on the way. So I guess whether we do or don't meet the size threshold that might attract the obligations, I think it will be an issue for most of us in the room in some shape or form. Yeah, good. Now, I guess when we are bringing in such a dramatic and sweeping policy like that, we want to be sure that we're not sort of cutting across the other things that are happening in the space. And I'm thinking here of new technologies. If we're seeking to deploy things like hydrogen, we don't want to be frustrated by the fact that we don't know how to report it. But it sounds to me like it's general enough that that won't be an issue.
Yeah, well, as I said, it'll be a matter of going through these disclosure requirements and saying, well, is this disclosable within, for example, when you look at climate change, you go through all the disclosure requirements within the climate change standard and say, what do we actually need to report here? And the idea is that the information that anyone who's involved in hydrogen is reporting will be reported using the same metrics so that you have that element of comparability and reliability.
Yep. Good. And just speaking of hydrogen, Rob, there've been some developments in the space, I hear.
Yeah, well, we had a lot of talk earlier about the hydrogen strategy, so probably don't need to rehash too much of that. But one thing I think is worth mentioning is the EU's delegated act on additionality when we're talking about electrolyzers, that they'll need to be connected to new renewable generations. So that should be a good driver for the development of new wind and solar. But the hydrogen strategy itself, I actually thought it was quite a well-considered document. It rightly focused on the hard-to-abate sectors, as Julian was mentioning earlier, because that's where the most sensible use cases for hydrogen.
No mention of airships?
No, we're not. None of us are going to be driving around in hydrogen-powered cars.
Oh, I thought Jonathan was softening on toward the end of his.
The economics just don't stack up. Electric cars will always be far cheaper. So anyone who's looking at hydrogen cars is wasting their time, really. But, oh, sorry, I've probably offended someone in the room.
And private wires, I think there's been some movement in.
Yeah, well, actually, private wires and hydrogen is a good mix, and there's a consultation out there at the moment on private wires, actually, because at the moment in Ireland, the Electricity Regulation Act only allows for direct lines in very limited circumstances. If you've been refused a grid connection, and I don't think you are aware of that ever having happened, then you can put a direct line between your to your generation. And the other one is if there's a connection dispute and it's determined in your favour, and that says to build a direct line, then you can. But other than that, they're just not permitted. So so hopefully, well, this consultation is the first step towards bringing in a policy on private wires. So it's a very long consultation, 173 separate questions, but and you kind of read through the questions, and there's a bit of a kind of a negative kind of focus a lot of the time. They seem to be focusing on the drawbacks of private wires rather than the positives of them. So that's an indication of where they're leaning. But they do talk positively about using private wires with hydrogen.
There is indeed a dusty, unused corner of the Electricity Regulation Act, 1999, an act that I'm particularly fond of, and it's
I think you're
done
fond of it than I am, Peter.
Done a lot of heavy lifting over the years, but not in that area. And it's still doing a lot of work. It actually got amended 7 times last year, which is quite a bit of activity. Again, it's the waves of European tweaks. Things like the Clean Energy Package eventually percolate down to the Act. But the problem is, and same with private wires, they kind of stop there. They then need to be operationalised, and that just hasn't happened. So hopefully that's going to change. Now, are we on the clock, Jonathan?
We're waiting to. I've got the results of the poll coming in, and we can put that to them, and maybe the guys might want to discuss afterwards.
Well, Jay is itching to tell us about the maybe the JR implications of the new planning regime. So
yeah, sure. The changes to the judicial review system that are set out in the current Planning and Development Bill. So that's aimed at reducing the number of judicial reviews that go through the system, and also speeding up the judicial review process. So as you know, a lot of planning permissions at the moment are ending up in judicial review. So in terms of speeding it up, there are set timelines that are put into the bill for the judicial review stages of the process. Those can be varied by the court, but at least there are now timelines set out there. In terms of the reducing the success, let's say, maybe of those judicial reviews, obviously before I was talking about the kind of resources for the board and making sure the decisions are correct, but also within the bill. So currently, if an applicant lodges a judicial review application, normally as the local planning authority, the board, and also the developer, you wouldn't normally know about that until the permission stage has been granted. So you have the permission stage. If you get through that, then you have the main judicial review application. You wouldn't normally know about it until after that permission stage, whereas now the applicant, as soon as they issue the proceedings, they have to notify the planning authority as well as notice parties such as the developer as well. Then you have an opportunity to say, do you want to oppose that or not? If you do want to oppose it, then the court has to consider various tests, such as whether there are substantial grounds for the application, and also, quite importantly, whether the applicant has standing. So are they directly or indirectly affected by the proceedings? And then if it relates to an environmental impact assessment or appropriate assessment development, then there are also further criteria, such as they need to have been a company that's been established for at least a year, they have to have 10 members, they've had to agreed as a company that they want to initiate judicial review proceedings. So one of the aims of that is against neighbourhood organisations who are unincorporated, and currently there's a lot of judicial review applications coming from that. What I would say is that the bill will be subject to European law, such as the Our House Directive, and access to justice on environmental issues. So that it may change before it comes into its final format. But that's currently what they're looking at. Another thing they're looking at is an administrative or legal aid scheme. So currently, as an applicant, if you lodge judicial review application, if you're successful with that application, your legal fees are paid by the planning authority and potentially the notice party. If you're unsuccessful, then you only pay your own costs, whereas which means you've got a very low risk level in bringing those applications. And also the legal team as well can think, well, actually, if they are successful, they get pretty good kind of legal fees. Whereas with the legal aid scheme, it may reduce the legal fees that applicants are potentially getting as part of this, which may in turn reduce the number of judicial review applications as well. And one further final change I was just going to mention was also that once judicial review applications brought forward, if the local planning authority noticed that, agrees that there was a mistake, they can put a stop on the proceedings, a stay on the proceedings, go and fix the mistake and come back to court and say, okay, we've fixed it, rather than waiting for the application to go, the whole way down the line. But I think that will only just kind of deal with minor kind of technical errors.
Yeah, that does sound more efficient, but blimey, just the sheer scale and number of changes to that area of planning alone, the procedural stuff, it's quite remarkable. So plenty to read there as the bill appears, hopefully, and then makes its way through the process. Of interest to me also was, especially in the context of the talk about data centres, I understand there's going to be a more joined-up way of national planning policy percolating down to local authorities. I mean, we've seen, local efforts to put moratoria on data centre development and things, which might not be as easy in the future because there will be a more structured way of national plans being implemented. Is that right?
Yeah, so at the moment, so if, for example, you have the data centre policy and it comes out as a specific, what they're going to be called as national planning statement, then a local authority has to review that national planning statement and consider whether its current development plan is materially consistent with that. And if it's not, it has to change its development plan to make it materially consistent, or otherwise notify the Office of the Planning Regulator. So what that's aiming to do is to, as you say, to make more of an alignment between national policy and local policy. So, for example, as a developer, if you're putting in a planning application and there's not that kind of alignment, you might have uncertainty in terms of, actually, is my type of application, which is consistent with national policy but not local policy, is it going to be refused?
Yeah, well, different levels of government behaving in inconsistent ways doesn't make sense to anybody, I don't think. So, yep, that sounds positive too.